Hello, everyone. My name is Jennifer Hill, and before we get underway this evening, I wish to acknowledge the traditional custodians on the land where we are, and I pay my respects to elders past and present, and extend that respect to other Aboriginal people who may be listening to this event. I'd also like to welcome everyone who is participating in tonight's Bob Baxt AO address. And I say that on behalf not only of my centre, the Centre for Commercial Law and Regulatory Studies, or CLARS, at Monash Law School, but also the Data Futures Institute that we're delighted to be joining with this evening. And a particularly warm welcome to our speaker tonight, Professor Viktor Schönberger, who is joining us from Oxford. I'd also like to mention we're very grateful to Allens for their support in this year's event. Bob Baxt's wife, Ruth, and his daughter, Simone, watching the event from Allen's offices here in Melbourne, and we're going to be joining with them later to speak to them after the event. For those of you who attend our events regularly, you'll know that this is only the second year in which we have held this Bob Baxt AO address in corporate and commercial law, but it is now an annual event, and we're so pleased to be able to have this wonderful event to commemorate and remember the impact that Bob Baxt had on Australian corporate, commercial and competition law. And he also had a great effect on Monash Law School, where he was dean for a number of years. And so before we start the substantive part of tonight's seminar, we're going to hear from Rebecca Maslin-Stanage, who is the chair and senior partner of Herbert Smith Freehills. I asked Rebecca if she would give us some of her memories of Bob Baxt, because Rebecca knew Bob in many, many different contexts, and she is one of Australia's leading M&A lawyers, and I know that Bob was very much a supporter of Rebecca from her career, and Rebecca was very much a supporter of Bob. So I'm delighted to have Rebecca here with me this evening, and she's going to say a few words about her recollections of working with Bob over the years. So over to you, Rebecca. Thank you.
Thanks, Jennifer, and thanks for giving me the opportunity to say a few words about Bob. Now, when Jennifer asked me to do this, she did mention, oh, it's going to be at Allen's, is that okay? And of course, I said, completely fine, you know, the more people who are celebrating Bob, the better. But I do have to admit, I just did have this slight inkling of, hang on, we own Bob, he's our legendary partner. And then I thought, no, of course at Allen's, he's equally their legendary partner. And then I thought, on the Law Council with Bob, we also thought he was ours, both on the Corporations Committee and the Competition Committee. And then I thought about the AICD, and I'm sure that they thought Bob was theirs. I could go on. I know when I arranged a conference for the court, the number one person they wanted to make sure we got there was Bob Baxt. So it feels like we've got quite a shared sense of ownership of Bob, and it just shows what an incredible array of things he was across and passionate causes that he was pursuing. Now, of course, Bob was incredibly smart, and what I've just spoken about shows the absolute breadth of what he did. And many people like that are perhaps a bit intimidating or hard to get to know, but Bob was not like that whatsoever. You couldn't meet a warmer person and a person who connected others as well as Bob did. So while he was very happy speaking with a federal court judge and explaining why they had not actually appreciated the full essence of the law in some opinion that he had a different view on, or with a senior regulator and telling them the evils of infringement notices or something of that nature, he was equally at ease speaking with the most junior, bright, up-and-coming lawyer, and often incredibly enthusiastic about what they were doing and the progress they was making and taking that personal interest in their careers. And I thought as I reflected on this, Bob really had that wonderful sense that you don't get in that many people of his level of achievements, where he really saw the achievements and talent in others and valued it and was excited about it. And he was never happier than mentoring juniors coming up. Jennifer mentioned Bob was a supporter of mine, and I really appreciated that. But in a similar way to the fact that I kind of thought we owned Bob at HSF, I've met so many other partners and lawyers around the place who feel the same way, that Bob took a personal interest in them and really supported them actively in their career. And some of that even only came out when we were at his funeral and have had subsequent discussions, when it just became clear how many people's lives he really influenced, how many people he encouraged, and the scope of that legacy that he has had. And I must say, particularly for female partners around a number of different firms, we really appreciate that he went out of his way to do that. And that was before it was fashionable to try and advance the careers of women in law. Bob just did it, and he made me think he was completely gender blind and doing it on talent alone. But I suspect he really had an eye on people who he could use his influence to support, and that he was doing that quietly. And how on earth he had the time to do it on top of everything else is a complete mystery to me. So while I started out with loving that sense of ownership of Bob for our firm, for myself and for many others who I know he supported generously, I can't help thinking part of the reason it feels so natural to be going to a Bob Baxt event and for him to still be part of our lives, even though sadly Bob's not with us anymore, is because of that influence he had, the scope of people he bonded with, the scope of people he helped, and the fact that really we've all got that shared ownership of Bob, and we're happy to share that ownership because that is his legacy. And it's fabulous, Jennifer, to be arranging events like this, which let us continue to benefit from Bob, and he would be so happy and delighted that that's what we're doing. So thank you. I just wanted to share those few thoughts, and I'll really look forward to speaking to those of you who are here personally shortly.
And I did just want to say, as I listened to Rebecca, everything that she said about Bob Baxt rang so true, except when she said, I don't know how he found the time to do it. I know in the background helping him was Ruth, and Ruth was a very big part of Bob's ability to juggle so many things. The other thing that really stands out for me with Bob is how much he loved Australian corporate lawyers and commercial lawyers and competition lawyers interacting with international scholars. And so I know that he'd be thrilled to have Viktor speaking to us tonight. So I am going to now pass across to my colleague, Chris Marsden. Chris is the Professor of Artificial Intelligence, Technology and the Law at Monash University, and he is going to introduce Professor Mayer Schönberger and his address. So over to you now, Chris.
Thank you, Professor Hill. Let me just say very briefly just what an honour it is to be involved in the Bob Baxt annual address, and particularly tonight, when I think we have a chance to really see some of the extraordinary work that Viktor has been working on over the last couple of years. So I'll introduce Viktor. Viktor, I will not steal your thunder by mentioning anything at all about the talk, but I just want to give some both Viktor's resume, but also some personal note on why I'm so pleased that Viktor is able to join us this evening. And I should say, of course, Viktor was joining us from the morning in Oxford, so we are particularly glad that he's been able to join us with the time difference. So Viktor Mayer Schönberger is the Professor of Internet Governance and Regulation at the Oxford Internet Institute at the University of Oxford. And Viktor, in addition to having degrees from Graz and also from Salzburg and also from the London School of Economics, also was the founder of Icarus Software while actually undertaking his first degree, very successful software company long before most of us had heard of the internet as a software entrepreneur. Viktor then spent 10 years on the faculty at the John F. Kennedy School of Government at Harvard. And that's where I first met Viktor in the last millennium when we first met each other. And then Viktor spent 3 years at the National University of Singapore, which was a little closer to us in Melbourne. One day we will get him here in Melbourne, I'm sure. And then now more than, I think, 11 years in Oxford. Viktor has also been a huge support for the way in which we think today about data protection, privacy, and the way in which the companies which have developed on the internet and elsewhere have used our data. And he's the author of, I will now say, I believe it's 7 books with the latest book, although I may be incorrect on that. Wow. 8, and the 2 in particular or 3 in particular that I want to mention are Delete, the Virtue of Forgetting in the Digital Age, which was itself easily 5 years ahead of anybody's real thoughts about how we would move towards a world where the perfect memory of the internet and of databases could be forced to forget some of our less relevant passages of our past. Something for which I think we are all grateful in 2022. Secondly, big data, a revolution that transforms how we work, live, and think, with our friend Kenneth Cukier from 2012, which captured, I think, very much the move towards our understanding of data science and the way in which data would affect our environment going forwards, not just on the internet, but across the whole range of socioeconomic forces that shape our society. And thirdly, Reinventing Capitalism in the Age of Big Data from 2018 with Thomas Ramger, which explains very, very clearly the challenges that this raises, not just for business or for law or indeed for some of our micro social relations, but actually across the whole organization of the way in which we think of societies in the 21st century. So astonishing work. I will also say on a personal level that Viktor and I have had many, many exchanges over the years, in particular when Viktor chaired, and indeed chaired, was the inspiration for the Rushlakon conferences on the information revolution outside Zurich in the period 2001-2007. And I hope that some of the things that we said there helped to shape some of the things that ended up in the books. But I will say I got a lot more from Viktor in those exchanges than I think that I possibly could have given him. So he's been a huge inspiration to my work over, as I say, more than 20 years. So with that, I will pass over to our special guest to give the annual Bob Baxt address for 2022, Professor Viktor Schönberger. Viktor, the floor is yours.
Thank you very much, Chris. It's a great honor for me to be speaking to you tonight and to engage in a conversation or a discussion about some of the pressing issues with respect to digital platforms and the digital economy. Fortunately, I had switched the automatic color correction in Zoom on. Otherwise, you would have seen me blush while Chris so kindly told you about my background. He was, of course, exaggerating greatly, but I am most grateful for his kind words. Thank you very much, Chris. I'm just an Austrian dilettante trying to make sense of the many digital phenomena that I am encountering. On that, let me get going. Let me start, and let's look at the internet right now and the state of the internet. And when we look at the internet, when we look at what companies there are, how we engage, transact, interact online, what we mostly see is very large companies like Google, like Facebook, like Amazon, like Apple, operating platforms there. Airbnb, Uber are other examples, of course, and there are a number more. Now, these companies have sometimes been called digital platforms. I don't like particularly the word digital platforms, or the description, the label platform, because it kind of hides in plain sight what they are actually doing. Some of my economist colleagues in the United States called them superstar firms, with a little bit of an irony in it. And I think that's perhaps a better way of characterizing them. But they corner the market. There are huge, gigantic players commanding a huge swath of the market of online transactions and interactions. And that has a lot of people worried. But it's not the first time that we are worried about the concentration in markets. In fact, when we go back in legal history and think about when in earnest competition regulation, antitrust regulation started to come into being, more or less in its current form, we have to go back about 100 years. To the steel barons and the railroad barons of the United States, the Carnegies, the J.P. Morgans, the Schwabs, who really commanded and controlled huge portions of the industry in the United States at that time, pushing the political debate and pushing political players, including Teddy Roosevelt, to really advocate very strongly, for stringent regulation. And that is what happened more than 100 years ago, that we moved towards regulating anti-competitive behavior, that we moved to regulate trusts, to bust trusts. And we are doing this by looking at the behavior, the negative behavior of these industry players and trying to regulate that behavior. So for a very long time, antitrust has focused on regulating behavior. And that has worked more or less okay. Markets stayed more or less competitive in many sectors around the world, and especially competitive in countries where regulators and enforcement agencies made sure that antitrust rules were enforced swiftly and stringently. So that should also work perfectly fine in the digital world, except it doesn't. When we look at the digital superstar firms, what we see is that despite rumblings from antitrust experts and regulators that they need to behave, the size of their market share is still increasing. For Amazon alone, just before the pandemic, the market share in e-commerce in the United States, consumer e-commerce, rose from 43% to 48%. That means that about 1 out of 2 US dollars spent in e-commerce today goes into Amazon's coffers, at least initially. And that's a very significant market position. So why is antitrust not working effectively anymore vis-a-vis those superstar firms that cropped up on the internet? And to understand this and to then come up with a better regulatory approach, I believe we need to take a step back and understand what the reason is for large companies to grow larger. So when we go back the 100 years or so at the beginning of industrialization in the United States, or 150 years, 200 years, beginning of industrialization in the United Kingdom, what we see is that, of course, since the very beginning of times of industrialization, large companies could produce more cheaply and therefore became larger and larger over time. Scale and scope effects have led to companies that are already large to become even larger because they can produce more cheaply. And that has led almost across board to a concentration of markets. So we see this concentration in markets whenever we look at the advent, not just of railroads and the steel industry or the telecommunications industry in the United States. We see it when we look at car industries. We see the rise of the model of Fordism with very large scale, vertically integrated production that ensures that all scale and scope effects are fully reaped. So scale and scope leads to concentration of markets. What can we do about this? Lawyers tend to think we need to regulate, we need to keep the markets competitive. But our antitrust regulation is not the only, or perhaps even the real reason why markets have stayed competitive in so many countries around the world, despite scale and scope effects. The real reason is something that another emigrant Austrian by the name of Josef Schumpeter theorized almost 100 years ago. Schumpeter looked at concentration effects in markets and also saw that there was a counterforce. And he focused on that counterforce in markets. And this counterforce was nothing less than human ingenuity. Schumpeter was enamored with the ability of startups and entrepreneurs to take great ideas and then to make better products or novel products and services out of those ideas, to transform them into innovation. And so for a long time, as Schumpeter put forward, scale and scope effects have been balanced by innovation effects, by the triumph of human ingenuity that enabled startups and entrepreneurs to push incumbents off the pedestal because they were not able to produce a cheaper widget necessarily, but they produced a different and oftentimes a far better widget. And that has fundamentally led to the fact that competition was rekindled, was fueled. And so innovation is the counterforce to scale and scope effects, and that keeps markets from concentrating too much in a number of sectors. Now, what do entrepreneurs and what do startups need most in order to perform their function of innovators that keep the incumbents on their feet and that enable competitive markets? Schumpeter was obsessed with one resource that he thought entrepreneurs need most. And it wasn't skills or human ingenuity. He thought that that was widespread and there were always entrepreneurs that had great ideas. But he really worried about capital. That is, if you want to take an idea and bring it to market, that bringing to market, that innovation process, as Louis Branscombe said, that innovation process requires significant amounts of capital. And so Schumpeter was worried, deeply worried, that those amounts of capital, the capital resource might not be available to those entrepreneurs. And so late in his life in the 1940s, late 1930s and into the 1940s, his mood changed and he became quite depressed because he thought that innovation would only be available, would only happen in large companies because only those large companies had the capital available. Fortunately, he was wrong. It wasn't the only thing that he was wrong, but here he was clearly wrong. He was wrong because of course, after World War II, capital became available to entrepreneurs, to startup companies, venture capitalists, angel investors came onto the scene and provided seed funding and provided later stage funding for startups. So capital was available, and that enabled and facilitated an enormous growth of innovation in the 1950s and the 1960s. It's not just the start of Silicon Valley, it's also was the start of Route 128 in Boston. It was the beginning of the digital revolution. It was later on in the 1960s and 70s, the beginning of the biotechnology revolution, all fueled and facilitated by this huge amount of capital that became available. And so in that sense, we should actually be living happily ever thereafter. Scale and scope effects on the one hand and innovation effects on the other hand balance each other out, and therefore markets stay competitive, even though there is an internal dynamic for concentration. So what happened? What happened in the digital or in the data age? Why this balance got unhinged? And that has to do, I believe, with the nature of innovation. I just explained that innovation has two components, a great idea, and then taking that idea and bringing it to the market, creating products or services that are really novel. In our data age, I suggest that more and more ideas need not just capital to bring that idea to the market by transforming it into a product or a service, but they need access to data. Access to data because today we see data-driven machine learning replace, not just complement, but oftentimes replace the old-fashioned innovation process. Now, you may look at me now and say, I'm skeptical. I still think the great ideas matter more than data or anything. But let me give you just one example out of many of how this plays out and why data-driven machine learning has become so important. And this example has to do with something that looks rather awkward, I have to confess. This is Google's prototype of a self-driving car or autonomous vehicle. But please don't look at this funny shape of this car. I wouldn't want to sit in one of those either. But think about what it means. You know, if we would move from cars that would be human-driven to self-driving cars, we would be able to move away from having to own a car to rather using a car as a device for mobility whenever we need it. That would increase utilization of cars dramatically. Currently, the utilization rate of privately owned cars is about 4%, which means that 96% of the time the car that sits there and rusts. And that's a terrible waste of resources. It's inefficient, it's highly unsustainable. These sitting cars, these underutilized cars, also take up huge amounts of parking space. So my colleagues in urban planning have calculated that if we move to self-driving cars, this would almost momentarily free up about 25% of parking spaces in cities, which would enable urban redevelopment at a scale not seen in decades. So there is a lot that in favor of autonomous driving vehicles, but the development has been very hard and tough and challenging. All of the big car companies around the world work on autonomous cars, on self-driving cars. So do, as you may know, digital superstar firms like Google. So in 2015, when the push towards self-driving cars really started in earnest, at the end of that year, the car companies as well as the digital companies had to report to the California Department of Motor Vehicle how well their efforts worked. And so let's look at that benchmark. It's only one benchmark, and it's a crude one to be sure, but a useful one, I believe, to get us understand the importance of data in this innovation process of autonomous vehicles. So in 2015, by the end of 2015, a self-driving car of a typical car manufacturer would go about 400 kilometers on average, without requiring a human intervention. So every 400 kilometers on average, it would require a human to sort of inject her or his wisdom by taking over the driving wheel, or by stopping on the brakes, or by just pressing the OK, continue button, which was most of the intervention needed. At the same time, the Google self-driving car was going on average 2,000 kilometers without human intervention. Why? What's the difference? And the difference is obvious when you look at the detail. Car companies are, and always have been, concerned about cost. And so when they thought about self-driving cars, they said, okay, so we'll put a couple of sensors on the self-driving car prototype to collect data. Let's just think about a budget, and let's put the sensors, the best sensors that we can get for that budget, onto the car. And that's what they did, and they collected some information, and then they milked the information to the greatest possible extent, and then they had a self-driving software. Compare that to Google, where Google said, basically, we are a company that we're printing money, and so we put every sensor that we can think of on the car, and then some, twice over. And so we collect, Google said, we collect data to the tune of about 1 billion data points a second for each car. And then if you have that huge amount of data and you milk it, you analyze it, you learn from it, you have a significantly better piece of self-driving software at the end. Now, over the next couple of years, car companies smartened up, and so they added more sensors, and they improved somewhat, except that most of this driving was done on highways. So 2 years ago, when companies, including Google, but also the car manufacturers, started driving in a city with their self-driving cars, they sent new figures to the California Department of Motor Vehicles indicating their progress. And Google had progressed quite dramatically. By the end of 2020, a Google self-driving car would drive 47,911 kilometers before requiring a human intervention on average. That's more than most people drive a year. In comparison, the Mercedes self-driving car at the same time was driving 41 kilometers before requiring a human intervention. And so what happened, thanks to data and data-driven machine learning, was that the innovation gap between classical car manufacturers and digital superstar firms has actually widened. That's the power of data. If you have it available, you can take an idea, and with the right amount of data, with an abundance of data, you can just learn so much more from it that drives innovation, that puts forward better, far better products and services. And we see it not just in self-driving, we see it everywhere in medicine, we see it in education, we even see it, believe it or not, in poker. The best poker player of the world is a computer, because it turns out that once computers watch other poker players play and bluff, they know how to bluff better than anybody else. So that means, coming back to our fundamental setup, that innovation that is driven by data and done through machine learning, in addition to an initial idea, is no longer the purview, is no longer the expertise of mostly entrepreneurs and startups, but actually now moves over to very large companies, because it's the very large companies that have access to data. So very large companies have access to data more than anybody else. The entrepreneurs don't have access to the data. And that means that those large companies can be more innovative than the entrepreneurs could ever be. Not because they have the better ideas, but because they have the better beltway to move the idea to a final product. And of course, what this means is that competition in such a world suffers tremendously. Competition is under tremendous threat because those digital superstar firms can be far better at designing better products. When we look at competition and the competition landscape, for example, even in Silicon Valley, what we see is quite depressing these days. Startup companies 20 years ago, Chris, I still remember the dot-com bubble and all that, but 20, 25 years ago, digital startups in the Silicon Valley, if they were successful, they would IPO. They would become public companies. 3 out of 4 would actually IPO. Fast forward about 20 years later, as Mark Lemley and his colleagues at Stanford have shown, most startup companies that are successful in the Silicon Valley are looking to get bought up by some of those digital superstar firms. Here in the back, you see the graph. The black bar is IPOs, and the blue bar is acquisitions by large digital superstar companies. So what's happening here is that the young entrepreneur enters a kill zone after having had a good idea and developing a prototype. She or he needs access to data to put that idea into and transform it into a product, doesn't have that access to data. And therefore, the best that she or he can do is to actually sell the startup to a large platform that has the data. And that's what we are seeing. And that has huge repercussions for competition, because it basically means that those small startups that were initially, 20 years ago, 30 years ago, 40 years ago, able and capable eventually to push the incumbent off the pedestal, are no longer able to do that. They get just bought up by the incumbent, and that's the end of that story. So it deeply depresses competition. But it's not just that. It also limits our ability to innovate as an economy. Not only because the entrepreneurial startups can no longer truly innovate, but also because there isn't strong competition that the large incumbents feel, and therefore the incumbents become complacent. There are numerous benchmarks for Silicon Valley digital superstar firms that show that their pace of innovation has actually slowed rather than sped up over the last couple of years. Digital superstars were far more innovative in the teens, in the early years of this millennium, than they have been in the last decade. But there is an even worse problem than just competition and innovation, and that is, as we come to depend on a very small number of very large digital superstars, whether it's in e-commerce, whether it's in email, search engines, you name it. When we become dependent on them, what we lose is resilience that is built into normally the market system. There is a reduction in the number of suppliers of certain services, and that means we become more and more dependent on those suppliers to perform the services. It's a bit like if you are in a car going down the highway with 120 kilometers an hour, and suddenly you realize your brakes don't work, and you look around and you realize everybody has the same brake because everybody has the same car. And that means we are at an inflection point in economic and history where the ability to compete, to innovate, and to be resilient as an economy are shrinking quite dramatically. And so what we need to do is to overcome this. And that means to go to the root of the problem. Remember that it was data-driven machine learning that I identified as the change in the innovation dynamic. And if that is the real change, the underlying dynamic, then by broadening access to data and giving entrepreneurs and startups and smaller companies access to data, we can actually overcome this concentration effect that is really troubling the digital economy right now. And so we can regulate to increase access to data. Now, I hope you understand that this is really a kind of indirect way of inducing innovation and competition. It's not regulating by regulating behavior by prohibiting certain anti-competitive behavior. It is actually regulating so that smaller startups have the resource, the data resource available so that they become successful. Now, as we would regulate to force large incumbents to open up their data treasures, would that be possible? Has that ever been done before? Is this something that could be done? Or is this just a pie in the sky fantasy of a stupid academic? We actually have done it before in a number of instances, contexts, and variations. One particularly interesting case is more than 10 years ago when Google bought a digital back office provider for travel, particularly airline transactions called ITA. Google bought ITA for $1 billion. And the Department of Justice in the United States stepped in and said, yeah, Google, you can do that, but only if you permit others, including your direct competitors, to have access to the data. And so they forced Google to really open access to data in order to keep that particular market niche competitive. That wasn't the first time we had this this opening up of data and knowledge to competitors through regulation. Go back 200 years and think about patents. Everybody out there in the lay public always looks at patents and says, this means that for a certain period of time, 20 years or whatever, the patent holder has exclusive rights. That's true, but the flip side of the patent is that you only get the patent granted if you provide detailed descriptions of what the patent encompasses, so that once the patent expires, anybody can take it, can learn from it, and can utilize that particular piece of knowledge and insight. In a way, it is an access to knowledge just with a little bit of an economic delay built into it, but with a forced documentation function. The innovation that is patented needs to be documented in the patent application, sufficiently documented in order to be granted a patent. That is to ensure that the knowledge is actually not lost, but can be repurposed by others later on. And perhaps the most interesting but often overlooked case is one from the 1950s when AT&T, the American telephone incumbent, was sued by the Department of Justice for antitrust violations. And after a protracted lawsuit, the consent decree that the parties agreed to required AT&T to open up the entire patent pool of its famous Bell laboratories and make all of those patents, the transistor patent, microwave patent, laser patent, all of those patents available for free to all American companies. Overnight, that kind of subsidy of knowledge and insight provided opportunities for many startups in Silicon Valley because they now did not have to get a license from Bell Labs, from AT&T. They did not have to get the agreement of a potential competitor like AT&T. They could just go out and do whatever they wanted and put their idea into practice. And so ITA and Google, the US patent system and the patent system around the world, and the Bell Lab opening up of the patent treasure trove are examples of how we have regulated access to data and knowledge before. And this lever of opening up access by regulation has fascinated lots of governments around the world, especially in Europe, in the UK, in Switzerland, in the European Union, in France. Everywhere we see this pick up, but perhaps the most interesting and the most current development towards a push to broader access to data as a novel way of competition law and antitrust regulation in the data age comes from the European Union's Digital Markets Act that was just published in the EU's official journal earlier this week. And in Article 6 of the Digital Markets Act, there are two data sharing provisions in there, already built in there. The one is access to aggregated and non-aggregated data free of charge, and that large companies have to provide to their competitors. And the other is directed especially towards search engines. And there, they not only need to provide raw data, they also need to provide click data and view data on a reasonable and non-discriminatory and fair basis, a friend basis to their direct competitors. So what we see in both of these instances is now a legal mandate to broaden access to data. And this idea of broaden access to data now has an anchor in actual law. So what we see here is that change in regulating antitrust and competition issues from regulating behavior to regulating for innovation. I hope you enjoyed my talk. Thanks very much.
The world that we live in, of course, has removed applause, but I hope you can hear the kind of electronic applause echoing around the background, Viktor. That was wonderful. Thank you very much. I want to remind everybody that we do have 20 minutes or so for question and answer, and so please do feel free to enter a question into the Q&A panel at the bottom of the screen. Viktor, I feel kind of provoked into asking you something else about the DMA, and I should say I was actually at Alan's in Sydney, in the other Alan's office last week, talking about the DMA and how it might affect the law in Australia, where at the moment the Treasurer is considering a long-term standing panel of suggestions for digital market innovation. The DMA, of course, has a really powerful mix of identifying monopolies, this ugly term VLOPs, very large online platforms, which I think no one likes, but nevertheless, it's what we're stuck with. But also about using both access to data and interoperability to try to overcome these problems. And of course, what some people call AI, but which you much more correctly identified as machine learning, which also has this often the ugly scientific term in the UK of trusted autonomous systems. But we have the idea that we have algorithms that are self-learning and data to feed the algorithms. Do you need both? And has there been too much emphasis in, amongst other things, the DMA on interoperability to the exclusion of data? And if I can ask you a follow-up on that as well, we know that, of course, you sit on the digital panel, which has been advising the German Chancellor over a period of years. When you explain these things to the competition authorities, do they understand the need to address the whole of the piece, to not focus on opening APIs, which is the classic Microsoft remedy, but actually to focus, and of course, fining companies which have more money than anyone else in the world has ever had doesn't really do very much good either, except of course delay everything by 10 years. Do they understand the need to free up data? I mean, as you say, there is something in the DMA. How much more should they have done?
That's an excellent question. Didn't expect anything else, and of course, a big and loaded question to boot. Let me also add that I am no longer a digital advisor to the German government. With the change of government, the government decided that it needed no advice anymore, and so we are no longer advising. What was really interesting, and that's why I said this at the beginning, what was really interesting was that when we were in discussions, for example, with Chancellor Merkel on these issues, she was actually very attentive, very intensely listening and trying to understand this. So was Ursula von der Leyen before she became Commission President. And I think some of those echoes I hear from what von der Leyen says and does. Now, as you know very well yourself, the European Union and the Commission is a super tanker that at the same time tries to go into different directions and thereby cannot be easily steered one way or another. Thierry Breton, the industry commissioner, of course, wants to protect incumbent industries. You have his desire and the desire of the German economic minister to build up incumbent European digital superstars, the so-called digital Airbuses, as they are called. And billions have been thrown into this bet or thrown to this bet, which of course only are very large industrial subsidies to very large industrial players, and nothing really will come out of that. But what you see with the Digital Markets Act is that the European Commission tries to throw everything in the kitchen sink at the problem, not knowing what will stick. So if you ask me, yes, I'd like to have more data regulation in there, not just for the very large incumbents, but across board. I think that there are smaller seeming incumbents or those that have very significant market slices that also should be regulated, and their data should be made accessible to others. I want more general macro level data access rather than micro level data access. Interoperability, but also data portability still features in the Digital Markets Act. That has not worked at all in GDPR. Therefore, it will not work in DMA either. It sounds beautiful: human individual empowerment, low transaction costs, human mobility, empowerment of human volition, and all that BS, if I may say, but it hasn't panned out. We haven't seen it. I've talked to a large European insurance provider, and they have received tens of thousands of access requests to personal data, but less than 10 requests for data portability. in the first year of GDPR data portability. The data portability in GDPR is practically dead. I don't see a reason why the DMA should be able to bring it back up. And conventional antitrust measures, of course, are favored by conventional antitrust lawyers and conventional antitrust economists, because that's the tools that they know and are familiar with. What is interesting with the DMA is that actually the European Union was daring enough to go beyond that.
And it's interesting to think about the dynamics going forwards. The European Union, of course, is as you say, a supertanker, but a supertanker which, once it's going in the direction of data sharing and interoperability, perhaps these are things which are now permanent features of the landscape, albeit much slower than either you or I would like to see. You also, I noticed on the slide, you mentioned moves towards reform in Switzerland and also in the UK. In the UK, there was the Furman review, which was actually a review by 5 experts, including not just economists, but also computer scientists as well. Is there much prospect of the UK moving in the direction that you and I would like to see? I'm conscious, of course, that as you say, as somebody with, I was about to say a foot in Austria, a foot in the UK, and a foot in the States, but that wouldn't work. But as somebody who's very aware of the policy going on in different parts of the world, do you think the UK is in a position to move fast, ignoring obviously the immediate chaos of government, but in terms of the actual behind the scenes work?
Well, I think, Chris, you put the finger on the problem. That is, the fundamental idea of Brexit was that they could move faster if they weren't shackled down by the European Union. When I engaged with career bureaucrats on changing data protection in the UK after Brexit, I said to them, surely you now want to loosen up a bit in order to attract more startups. And they said, oh, no, we don't want to endanger adequacy with the European Union, because it's our major market. We have very major data service providers here in the UK that do a lot of data processing for the European Union. We can't risk that. Well, then if that's your view, then why risk Brexit in the first place? If you still feel that you are economically shackled down because for economic reasons you cannot move freely and be more flexible. So it seems to me that the UK just has difficulties knowing what it wants. It wants the cake and eat it, but with the European Union, that's rather hard to do. And so I don't see much happening there. Overall, to pick one more strand from what you said earlier, overall, I see also confusion among policymakers, a confusion that they focus on algorithms and algorithmic regulation, which I think is the wrong approach, because tweeting the algorithms and working with them and how you use algorithms or how you use sort of machine learning to tease out insights from data, that is true insight, and insight should be protected. This is where value is being created, and that should be protected. And so algorithmic transparency and all that, I see rather skeptical, because that's where innovation is taking place. I want to have more transparency and access on the data side, the raw data side, if you want, because that's kind of the raw resource that you sit on, or you have been able to ingest because of the role that you perform in the digital economic setup. And so I would want to see us shifting away from algorithmic regulation towards more sort of data regulation. But again, if you throw the kitchen sink at a problem, you then need to wait for the dust to settle and to see what works and what doesn't.
I must say, there are so many people who have set their career towards the algorithmic regulation problem. That you're, and I should apologize for not mentioning that, of course, you have 2 books in the last year, Framers being the other book. I think that people are framing the problem in a way which is going to be very, very difficult to unpick. But if anyone can do it, you could do it. I want to raise a couple of questions that we have from the floor. We have a question here which is about the role of the interpretation of data. And the question is, presumably not all companies that have access to data can use it equally well in order to innovate. You can give people access to the data, that doesn't mean they're all going to do equally well. What do you think about the role of interpretation? Will big firms still be able to interpret, to innovate with that data better than other companies? In other words, you might give people access to data, but the fact is that the big companies who, as you say, are slower at innovating are still more able to work with that data than smaller companies.
There is some truth to it, no question. Very large companies, particularly very large smart digital platforms or digital superstars, have smart, skilled people on staff, have the infrastructure in place to do quite well. However, having said this, much of machine learning algorithm is today in the public domain, and then you can take it and you of course need to tweak it and change the various parameters, but the tools are not hidden. It's not like Coca-Cola's formula that's in a vault in Atlanta. These tools are really available. The same is true with data analytics and processing power. Thanks to cloud computing, even very large data sets can be calculated today at commodity prices. And that makes it easier for startups to just use cloud computing to do some of the heavy lifting. So in essence, cloud computing has been a bit of an equalizer when it comes to machine learning, data-driven machine learning. And a lot of the very smart experts in the field also prefer smaller organizations, prefer the entrepreneurial spirit, the sort of fun of setting sail and trying something new rather than being part of a very large organization where you have to fill in expense forms to the last dot. And so, yes, there is a bit of an advantage for large companies, but smaller companies also have certain advantages, and some of the advantages of the bigger ones that used to be there have become less pronounced, like access to algorithms or access to computing power.
Thank you. And that actually leads me on to a pair of questions, which I'll ask you together, because I think you might be able to help one with the other. So Alistair Younger asked a very brief but important question: thoughts on the concept of data trusts? And I want to put that together with Jess Wen, who's a Monash University law student. And Jessie, who I think may have got some cynicism from me possibly, wants to know, she's curious as to know what sorts of pushback we will see from large digital platforms to stop access to data laws. Are there ways that this can be achieved successfully, despite the obvious lobbying power of the big companies?
Very excellent questions on data trusts. That is a very interesting domain, and not an easy one, because what you're looking at, in particularly in the European Union, is a lot of small and medium-sized enterprises. Think about the automobile industry in Germany. It's some large tier 1 suppliers, and then lots and lots of medium-sized tier 2 suppliers. Each one of them collects data, but doesn't have enough of the data to sort of really gain a lot of insights from it. So they would actually be better off pooling their data with their direct competitors, which goes against everything in their in every instinct that they have developed, every competitive instinct. And so there is a lot of mindset change that needs to be done, in addition to some regulatory change. I worked in Germany, as you mentioned, and we got Germany to approve its data strategy. And in the data strategy, data trusts play a significant role. I'm not sure that this will be a silver bullet, but in certain areas, as I just sketched out, it will be helpful. It's not easy to set up right. It sort of trust needs to be open to everybody and so forth. Otherwise, we have the anti-competition problem all over again. With respect to how can we reach an agreement with the private sector, of course they are against it. The moment that Google was no longer forced to keep access to ITA data open, they closed it. The very day they closed it. So it does require regulation, but it also requires a pragmatic engagement with these large companies. And the point there is, I guess, that in the longer run, it's also healthy for them. It keeps them on the innovative path. It forces them to stay competitive rather than become complacent. And in that sense, I think it is useful to engage with them and to bring them on board, fully knowing that they will at times stall.
We have time for two more questions, and I'll put again these two together. So Greg Bamber suggests that, and of course he compliments you on your brilliant insights into the topic first, but also says that rather than giving the data barons such a flattering name as superstar companies, might it be more appropriate to call them what they really are, monopolists or quasi-monopolists? What else is to be done about them, bearing in mind that especially in the US, they employ the most expensive lawyers and lobbyists to fight any attempts to regulate them? And I should say Greg is a professor at the business school and also is in the Data Futures Institute here at Monash. And can I put that alongside another question, which is from Rosamund Krivenek? And Rosamund asked whether the European Commission's approach to regulating unauthorized personal data collection, by which I presume she means excess personal data collection, which would not be authorized in the GDPR, which shouldn't be collected or regulated by any actor. Can that somehow be remedied or made good by a requirement to share that data more broadly? I suppose this is a suggestion that TikTok or another company that's accumulating data in ways that may not conform to the law as we understand it should be made to share that data. Could that be a remedy which is more effective, I suppose, than simply fining companies in 5 or 10 years' time, which is, of course, what we do these days?
Yes. Yes, indeed. I apologize for calling them superstar companies. Greg is absolutely right. I use the label that is used by economists or by some economists, David Autor and others in the United States, to characterize those companies. But of course, we should find a less positively connoted term, perhaps. There we go. We're maybe back with the more neutral platform, although I really don't like platform because it obfuscates what's happening here. The question of what could be done and how to set it up really gives me an opportunity to come back to the data trusts one more time. One of the problems that I have with the data trust is that, this is a pool of data or a lake of data, whatever you call. And I would prefer potentially a more decentralized approach where a startup is going to a large incumbent and accessing the data there, and then going to another large incumbent, accessing the data there. And then the flows are more decentralized rather than creating a very large central pool or lake, because whatever you have that is centralized is also more prone to cybersecurity challenges. And I would be a little more worried about that. Also, the proposals that I have made at the European and at level and at the German level, for example, Thomas and I wrote in Access Rules, the book about this. Our proposal is that large incumbents wouldn't have to share all of their data, but only a randomized sample of it. In that sense, that would still be a sufficient data gift to the entrepreneurs and the startups, but wouldn't reveal everything that they have. Which brings me to the question about personal data. The debates about access to personal data are almost or oftentimes quite ideological, if not religious these days. So the moment you say, well, and then we have data that we let others access, somebody is saying, but every piece of data has a personal dimension to it, with very few pieces of data perhaps being excluded, like weather data from satellites or so forth. And so therefore everything is personal data, or pretty much everything is personal data. And then when you say, well, but you can pseudonymize or depersonalize with sufficient tools, if you're careful enough, then people will say, but researchers have shown that you can always repersonalize. You can always take the anonymity away. And that seems to be the killer argument, and that kind of ends the discussion. And I think what we need is a little more pragmatism there. If the re-identification is so cumbersome and difficult and challenging and costly, that it doesn't make much sense for a company to do it, then I think that kind of depersonalization may be sufficient. We are using passwords that are sufficiently secure, but are not perfectly secure, as we know. And still we transact online. So I think we should be a little more pragmatic when it comes to access to what used to be personal data that we have depersonalized or pseudonymized with appropriate tools, and we should make more of those tools available.
Thank you. Viktor, we're just getting going. You and I could carry on for hours, I'm sure. I want to thank you so much for giving the Bob Baxt annual address and for your generosity in answering the questions that we have from the audience, and even mine, which is extremely kind of you. I know that Jennifer wanted to offer her thanks as well and to rejoin us. So Jennifer, let me pass over to you.
Thank you so much, Professor Mayer Schönberger. That was a marvelous, marvelous address. I just wanted to thank not only Viktor, but also Chris for helping me chair this, and Rebecca for some great comments about Bob Baxt. And I'd also like to thank a couple of other people. We've got the sun coming through the window here. I wanted to thank Joanna Batstone from Data Futures Institute for agreeing to join with us in this year's event, and also Richard Spurio for Alan's support. And for the people that made it work so smoothly behind the scenes, if I could just thank them, there's Heather Trevisan and Marco Romero from Monash and Sarah Davies from Alan. So thank you all so much. We have a seminar, a law and business seminar, actually on this Friday. It's on what's a director to do, directors' duties in times of COVID. And that's going to be by another Oxford professor, Professor Kristen Van Zwieten from Oxford Law School, with Ruth Higgins from the New South Wales Bar as commentator. And you can find all those events on the CLAR's website. We wish you were here in Australia with us, Viktor, to have dinner with us, but I'm sure we'll get you out at some point in time. So I'm so grateful to you, and it's been a marvelous evening. Thank you very much, everyone.
Thank you. Thank you very much. Thank you.